Hello and welcome. This presentation is about the practice management element of running a mediation practice from first contact to the intake sessions. And what we're going to look at is the ethical and practical steps for mediators. Before I proceed, I'd like to acknowledge the traditional owners of Australia and pay my respects to elders past and present. I come to you today from the lands of the Gunai-Kurnai people in Gippsland, Victoria. What we're going to look at is why the pre-intake stage really matters. It sets the scene for the mediation and really can make the difference of whether a mediation proceeds or not if you're in a situation where you're receiving inquiries either by phone, chat, text message or email. The background that we're going to use is the AMDRAS ethical framework. The new standards are out. There's been some minor updates to the standards and improved numbering for referencing. The version is October 2025. You can go to the Standards Board website, amdras.au, and download the latest copy. The key domains that apply in this stage before you do your intake or pre-mediation sessions: professional conduct, informed participation, confidentiality, ensuring your competence to facilitate the particular type of mediation, and ensuring that it is a fair process. Just a reminder, your ethical obligations begin before the mediation begins. So here's a little process overview just to make sure that we're all on the same page with what we're actually looking at. The referral or initial contact, somehow or other, you're notified that there's a case. Follow-up is really important here. If you fail to follow up, the client may go elsewhere or decide that this isn't appropriate for them. You're going to need to do some sort of initial screening or conflict check. It depends on your context, whether there's likely to be conflicts of interest occurring that would mean mediations with you isn't going to be appropriate. And sometimes the actual situation isn't appropriate for mediation. So if there's a conflict or it's not appropriate, you'll refer the clients to someone else or a different process. There'll be a stage of gathering information and clarification. You're going to need to provide information to the client. Generally, that would be in the form of your agreement to mediate. It may be a costs sheet, other information, so that they can decide whether they want to proceed to the first generally paid session, which is the pre-mediation with you. If they don't choose to proceed, then you'll close the file, potentially refer them somewhere else. And there may be some further eligibility and suitability assessment from that information that's gathered. So the first stage is the client deciding that they don't want to proceed. The next one is with a bit more information deciding that it's not suitable. And again, you'd refer and close the file. If everything proceeds as normal, whoever needs to pay for the service has paid, then you'll start your pre-mediation with party A, and then party B, and then your mediation. Some services in this information gathering and eligibility suitability may contact party B. There's considerations around that. Generally, it's a good idea to do your intake with the first person first to make sure that it's appropriate, there's no unknown risks or concerns before you disturb the second party by contacting them. As with everything in mediation, we need to apply our professional judgment to the specific circumstances, refer back to your obligations if you're in doubt, or contact your professional association. So let's look at each of these stages one by one. Referral or initial contact. Our ethical focus is on confidentially handling inquiries. So think about your context. Are you protecting client information? Privacy laws are relevant here, and our obligations as accredited mediators. We need to be thinking about avoiding conflict of interest or dual roles. If you're a lawyer or a counsellor or someone like that, you wouldn't morph into a role where you're then going to be providing mediation because you've already established a deeper relationship with one of the parties. And ensuring informed consent. So again, we're not locking people into something that they don't know what it is that they're making a commitment to, thinking about how we're going to get the information. Some practical tips: keeping a standard inquiry log, depending on what software you've got available. That might be in a client relationship management software. It may be, if you don't move around and you're in one place all the time, it may be a physical log, book or ledger. Most likely it's going to be something in an online resource if you've got access to SharePoint or Google Drive or something like that. You'll probably have a log in Excel or Sheets or whatever where you can keep some basic information. It's a good idea to keep track of where your referrals are coming from if you are trying to build a sustainable business. You need to respond neutrally or respond in the mindset of a mediator. Clearly avoid giving legal advice if you are a lawyer, other advice if you're not, or providing your opinion. So you don't want to align with the first person that contacts you. So really think about providing process information, so explaining what you do, your process, what the next steps are, and certainly don't make any assumptions or promises about outcomes. It's highly unethical for mediators to promise a specific outcome because we don't control the outcome. Our role is to facilitate a process. It's up to the participants whether or not that's going to lead to an agreement or other outcome. The next stage is that screening and conflict check. So you've got some information from that first contact. This might all happen in one session. It may be different people. You may have a contact service that you've contracted to take those initial inquiries. But at some point, you're going to need to ensure that you're starting to screen about suitability. So you've got some requirements under AMDRAS regarding your impartiality and competence. So if someone's asking for a type of mediation that you don't have training, so for example, you're a nationally accredited mediator and they need family law mediation, refer it to an FDR practitioner. They have protection of the Family Law Act. You don't. They have a postgraduate level training in family dispute resolution, in family law mediation. You don't. So, it's very hard to argue that you have the competence to do that work. Confirm that there's no prior relationships or conflicts. So practical considerations, using a consistent checklist is a really good idea to make sure. There might be some situations where there is a prior relationship. If you're working in a small regional area, you may know a lot of people. And so it's really following the procedures that are established in the standards for dealing with potential conflicts of interest, discussing them. If all parties agree, proceed. If not, then refer to another mediator. Now, looking at that information gathering and clarification stage, again, our ethical focus, upholding transparency, so being very clear about all relevant information and not aligning to the party you're dealing with at this point. It's really important that we avoid creating a power imbalance or an unconscious bias in these early communications. Don't align yourself with the first person who's contacted. Remember your role. And the practical considerations. So gather enough details to understand the nature of the dispute, the number of parties and the issues without making judgments or trying to solve the problems. Something I see with newer mediators is that they might spend an hour or more on the phone in this phase. That's not what it's for. You shouldn't be doing a full intake. You're trying to get a brief understanding of the issue in order to determine, is it within your competence? Is it appropriate for mediation at this stage? You're not going to do a full risk screening. This isn't an intake. It's information gathering and clarification. It's not a pre-mediation session. You might need to explain a little about the process so that people are able to make informed decisions about moving to the next step. Now, assessing suitability for mediation. Now, I am not talking about the pre-mediation or intake, but we are starting at this pre-mediation stage, still looking at whether it's suitable. It's part of our obligations to continually assess, giving safety, capacity and willingness to participate. Some of the practical considerations, we're looking at power imbalances or intimidation. We need to repeat this process with the second person. Often there's different issues going on there. Are there barriers to communication or mental health issues? Is there going to be a need for interpreters, or are there other accessibility barriers that need to be considered before you can do your pre-mediation session? Are there legal barriers? Are there safety orders? If there are, you need to get a copy. You need to be absolutely certain that it does permit mediation. If there's any limitations on what is permitted, all of that needs to be ascertained before you do a pre-mediation. This is why I recommend you do a thorough check and generally proceed to pre-mediation with party A before you contact party B. But again, might depend on the context. Document your decisions and rationale. If you do decide that it's not appropriate or it's not appropriate for you, make sure you keep a file note. It isn't correct that mediators don't keep any information about their cases. That's just not correct. We have normal professional obligations to manage our case management. You don't need to keep copious case files. But if you're making decisions such as not to proceed, if you have a duty of care and you're concerned about someone's safety and you contacting the police or someone else, make a file note. If someone's giving you permission to breach confidentiality in order to speak to someone else, such as their lawyer or other advisor or personal advisor, make a file note of how that permission was provided and when. Those things, generally you keep those for 2 years after your mediation case concludes. You'd also keep your agreement to mediate, and when you get on to the pre-mediation or intake session, I recommend that you use an intake form and you keep a copy of that on the file as well. Please don't just trash your file. It's really unprofessional. Engaging each party separately. So really important that you're focusing on maintaining confidentiality between the parties or seeking permission. Now, confidentiality is a protection. It's a very powerful part of the mediation process. It's what makes mediation so effective, in that we are able to have confidential conversations with people with different interests and priorities. But it doesn't mean that with permission, information can be shared. So that may be, depending on the type of mediation you're doing, there may be information that needs to be collected. Certainly, if there's a safety order or if they're going to be negotiating regarding a contract or things like that, you're going to want to have a copy of that. There may be other information. So it's all about getting permission, being very clear about what is going to, what information is going to be shared with who. I'm not at all trying to encourage you to participate in mediator negotiation before you even get to intake. That's not what I'm talking about. It's really about taking a practical approach to how information will be managed between the parties or advisors as you're preparing. If language is a barrier, you may be using paid interpreters, or it may be a friend or associate who is assisting, depending on the financial circumstances and context. Think about how all of that's going to be managed, how you're going to build trust without alignment, without bias. and be very clear on the limits of confidentiality. So just saying everything's confidential is not good enough. That really isn't good enough. Be very clear about when and why you might breach confidentiality. If it's a situation where someone else is paying for the mediation and there's some information that's going to be provided to them, such as did the people attend, was an agreement reached, or even is the agreement going to be provided to someone else if it's in a written form, all of that needs to be discussed. The practical considerations at this stage as you're engaging each of the parties, clarify the process, roles, fees and expectations. With the second person you're contacting, it's always really important to be very clear. I'm not the other person's mediator. My role is to be independent, to facilitate a process for the two of you. The fact that they've contacted me first doesn't make any difference at all to my role. Do you have any questions about that? We're kind of morphing a little bit into the intake or pre-mediation, but you may need to get a little bit of information about what the issues are. So again, this is issue exploration frame. There's other models you may use, but this is quite a simple, what's the issue? Why is it an issue? What's the impact? What outcome would you like? I've got a problem with my neighbour about the fence. So what's the issue? Oh, well, they want to paint it blue and I want it to be black. Why is that an issue? Well, we can't agree and the fence is looking awful. So what's the impact? We're not talking to each other anymore and I'm really angry. I'm pretty sure they threw some dog poo over the fence the other day. And what outcome would you like? I'd like to try and work it out so that we can get the fence painted and move on. Okay. Got a pretty good idea of what the point is from that person. I'm not doing an intake at this stage, so I'm not going to start going through what are some options. We're just kind of a little bit like you might do in parties' opening statements when you get to mediation. Of course, we're looking to identify any risk factors, logistic constraints. So if we are going to move to first the pre-mediation or intake session and then the mediation, are there any specific issues around that? Are they going on a big trip overseas? Do they have a medical procedure coming up? Are they only available after hours? Do you do after hours work? All of those things. Your agreement to mediate is a really important document. If you're just starting out and you haven't got an agreement to mediate yet, get that built. It needs to cover all of your processes and support informed consent and transparency. It's important to ensure that parties understand their rights and responsibilities in the mediation process. It ensures that you've got evidence that you've provided all of the mandatory information, including information about how they can make a complaint. If you've got all of that in a written document, you get that signed early in the process, then that's a good confirmation that you've done that. Remember, it's not really sufficient just getting someone to sign a document. You need to make sure they do understand. And of course, you've got your privacy and data collection obligations. I had a copy of an agreement to mediate. I might just edit in a quick look at one. The integration of our ethical obligations, so just having a look at those in some of those domains. Professional conduct, so that's about maintaining our neutrality, avoiding dual roles. An example of how we might do that in practice is having our conflict check log, particularly if you're in a situation where you do have dual roles and conflicts of interest are something that's a common risk. Informed participation, so ensuring that the parties really understand the process, and that might be your pre-mediation calls. You can log that on your case management file. Confidentiality, manage information carefully between the parties, explain the limits early, don't fall into the trap of becoming a negotiator that's passing messages back and forward. Parties would love you to do that. So just be mindful of structure and process. There is a lot of benefit in people speaking directly if it's at all possible. Competence, only accept cases within the scope of your skills and knowledge. Another area where there's really specialist knowledge needed is elder mediation. There's a lot of considerations regarding working with family groups in that context, concerns around elder abuse, competence. all of that. If it's not an area you've been trained in, perhaps refer to someone else, or if you're still developing in that area, look at whether you can co-mediate or find support in other ways. Using supervision is a good support when you're just starting out, but it doesn't replace training and sector knowledge. And ensure that it is a fair process, so provide equal opportunities for both parties. So think about the context. Are you spending a lot more time with one than the other? Is one you find more engaging or interesting or pleasant? Are you providing the same information? Clearly, you're not always going to provide exactly the same information. If you're providing referral resources, the needs may be different for different people, but certainly looking for and offering support in a even-handed way is really important. So integration, so ethical dilemmas. These are some things to have a think about, and maybe stop the video, have a think. One of the dilemmas is a party oversharing. So this can often happen where they're so excited that they've got someone that will listen to them about these concerns that they've got, that they really give too much information. This can also happen with referrers who are advocates for one side. They can provide too much information. They may provide a very biased case summary that risks affecting your neutrality in the process. Another option, a party trying to get legal advice from you. So that's pushing your boundaries of competence. Even if you are a lawyer, it's pushing the role boundaries. You can't provide independent advice to people if you are mediating. It's a clear ethical issue, so making sure that doesn't happen. And pressure to accept an unsafe case can sometimes come down to suitability. There may be real concerns around coercion or even violence, and you need to consider in the context, is that a suitable process? So here are a few options that we might think about. Have a look at some practical tools. For your toolkit, your standard emails, maybe a client relationship management software. If you're a sole practitioner, software like HubSpot is quite low cost. Are you going to use forms to collect information from clients? Again, there's some readily available and reasonably low cost ways of achieving that. How are you going to receive payment? Are you expecting to do a bank transfer? Are you going to get some sort of payment processing system? As you're thinking about your toolkit and building it, what can I standardise and streamline? So you don't want to be wasting a lot of time on administration. It's an overhead that affects your business bottom line. Generally, mediators charge based on the time we're working with clients, and you need to charge at a high enough rate so that it covers your overheads. But the more you can standardise and streamline that, the better it is. Ensure that you're familiar with the AMDRAS standards. They're available on the key documents and guidelines page. The latest version, as I'm making this recording, is October 2025. And when you're doing your reflective practice, thinking about, was my approach ethical and procedurally fair? Did I comply with my obligations, or how did I comply with my obligations? Thinking about how you can improve that. If you're looking for some templates and tools, if you're a Mediation Institute member, in the members area, members documents, there's some sample documents there. If there's others that you're looking for, get in contact. You can also work with the AI to develop documents. If you've got a template for your invitation email for party B, you can put it through the AI and get a critique. It may help you improve your documentation. The same thing with your agreement to mediate. You can upload the document. So go to the mediation MIAI version that we've created, put your agreement to mediate in there and ask it to evaluate it against the latest AMDRAS standards and expectations for the sector and provide you feedback. It's a great way to review your documents. Remember, AI isn't the same as consulting a human expert. You still need to evaluate, ask it to reference which parts of the standards it's providing feedback against, and go and read the actual standards yourself. But it is a good time saver and helpful tool. If you're wanting to reflect on your process, let's say the number of inquiries that turn into actual mediations, or even the first step, the pre-mediation, is quite low. You can think about, well, maybe I need to improve my process. And low depends on the quality of the leads you're getting. If you're paying for generalized Google ads or something like that, you may get a lot of inquiries that aren't relevant at all. But you should be tracking every inquiry you get so that you can see what the rate is. Reflect on your process. What did I do when contacted? This is something you could ask your AI to help with as well. So work through it. I want to review my intake process from first contact to pre-mediation, and get it to ask you some questions about what you do and make suggestions. So context: who referred, what were the dynamics present, what happened, are you finding things are not suitable? Perhaps the information that you're putting out about your practice isn't clear enough. It's better to be more specific. I know it feels, when you're looking for work, it feels like, oh, I work with everyone. Nobody identifies as everyone. Everyone identifies as someone. So it's better to be more specific. Even if you can't bear to get down into a single small niche, maybe have 2 or 3 focus areas. That way people can identify that, oh, okay, this person works with my sort of issue. And then what next? How will I strengthen my process for next time? So perhaps set yourself a goal of increasing your number of inquiries that turn into actual mediation. Become familiar with the AMDRAS domains. There's good guidance built into the document around practice and expectations. So please do. And are there steps? Do you need supervision? Do you need to be talking this through? We run group supervision sessions. You can form your own little peer group supervision to have those discussions. You may pay for a supervisor who you meet with every now and again, or is there further training that you need? Hopefully that was helpful. Remember, go to the MI members and have a look in the folders for files and resources. Hope to see you soon.